more about what you mean when you say investor losses and how that differs from straight damages.
So I touched today on the different things that one can do to get to an accurate damage number. Investor losses is something that we use to calibrate thousands of different cases that we track in terms of their dispositions and their settlements. And as I said, it's a rough proxy for damages, but it's not equivalent to damages. So what we do is look at the market capitalization loss for a company, adjusting for what would have happened if the investor had invested in the S&P 500 instead of the company at issue. Now, obviously, you can invest in some company and make less money than you would have by investing in the S&P 500, and that doesn't mean that an investor is damaged or harmed by fraud, but it's just a way of scaling the numbers that you would get if you calculated the losses over a particular class period for a particular company.
Lori Mims, I haven't forgotten about you. Does the timely filing of a class action suit stop the running of the 3-year time limit for individual class members to bring their own claims under Section 13 of the Securities Act?
It does not, as to the statute of repose, which is the 3-year time limit in the 1933 Act. It does toll as to the 1-year statute of limitations. And so the statute of limitations is when the individual plaintiff knows or with reasonable diligence should have known of his or her or its injury. And under the Securities Act, the 1933 Act, that claim would have to be brought within a year. And so it does still toll that 1-year statute of limitations, but it does not toll the 3-year statute of repose.